Welcome to VALS' webinar, Fixing Victoria's Broken Bail Laws. I acknowledge and respect the Wurundjeri people's traditional custodians of the land that I'm on, and pay my respects to the elders past and present, and Aboriginal elders of other communities who are involved with VALS and the fight to achieve justice. Across Australia, we live on unceded land. Sovereignty has never been ceded. It always was and always will be Aboriginal land. I also want to acknowledge that there has been a lot of sorry business this year, and many of our communities dealing with natural disasters. If you're struggling, you can always contact VALS. We will help where we can and connect you to other services where needed. I'm Narita Waite. I'm the CEO of the Victorian Aboriginal Legal Service, and every day our organisation is incredibly lucky to work with individuals, families and communities who are directly impacted by the punitive and harmful bail system in Victoria. Being able to work with them and fight with them throughout the system and its unfairness is one of our biggest honours. Our custody notification service checks on the welfare of every Aboriginal person who is taken into police custody in Victoria, and our criminal law team, who are fantastic, represent clients in bail hearings. Our Wirraway specialist practice with individuals who experience harm whilst on remand and with families of loved ones who have been passed away whilst locked up in remand. Very hard but very critical work. Every day we see the way in which the current bail laws are destroying lives, families and communities. Currently in Victoria, the majority of people in prisons have not been sentenced. This is despite the fact that they are presumed innocent until proven guilty, and in many cases are charged with low-level non-violent offending that will not result in a prison sentence. This devastating reality is a direct result of the bail reforms that were introduced in 2018 following one extreme and violent incident. These changes disproportionately impacted Aboriginal women, children and men who were locked up on remand at much higher rates than non-Aboriginal people. Aboriginal women, who are the fastest growing demographic in Victoria's prisons, and the key driver behind this increase is the bail laws. In 2020 to 2021, 58% of Aboriginal women in prisons were on remand, compared to 48% in 2017. These consequences were not unexpected. And in fact, VALS and similar organisations warned the Victorian government prior to the implementation of these reforms that this would exactly be the outcome. Still, they persisted. The trauma and harm that is caused by the current bail system is widespread and multifaceted. The decision to lock someone up or release them on bail impacts their health and well-being, their connection to community and country, the health and well-being of any dependent children, or other family members in their care, as well, of course, as the eventual outcome of their criminal matter. For Veronica Nelson, a proud Gundijtmara Dhudhuroa Wiradjuri and Yorta woman, the decision to refuse bail and lock her up in December 2020 was a decision that directly contributed to a traumatic death and a devastating loss for her family and community. Our webinar today will examine the harm that is created by the current bail system and the reforms that are desperately needed to create a fair and equitable system. We will be discussing issues that will potentially include references to Aboriginal and or Torres Strait Islander people who are deceased. We will also be talking about matters pertaining to trauma, violence, abuse, racism, and of course language. If any part of that discussion raises issues or concerns for you, we encourage Aboriginal and Torres Strait Islander people to call Yarning Safe and Strong, a helpline run by the Victorian Aboriginal Health Service on 1800 959 563. And everyone can call Lifeline on 13 11 14. To start off our discussion today, we have a recorded address from Monique Hurley, Senior Lawyer at the Human Rights Law Centre Indigenous Rights Program.
Hi everyone, my name is Monique Hurley and I'm coming to you from unceded Wathaurong country in Geelong. I want to start by acknowledging the Wathaurong people as the traditional owners of that land and pay respects to elders past and present. It always was and always will be Aboriginal land. I also want to acknowledge that we're having this webinar at a time when, across the country, thousands of people have just attended vigils for Cassius Turvey, a 15-year-old Noongar Yamachi child who was beaten to death whilst walking home from school. It's also a time when the family and community of Warlpiri teenager Kumanjai Walker are grieving through a coronial inquest into his death in police custody. Governments across Australia talk of truth, reconciliation, and close the gap targets, yet refuse to take steps to dismantle the discriminatory laws and policies that continue to result in unchecked racism and the mass imprisonment of Aboriginal and Torres Strait Islander people across the country. The time for action is long overdue, with the mass imprisonment crisis particularly acute in Victoria, where the number of unsentenced people in prison has skyrocketed during a time when crime rates are actually dropping. The alarming growth in the prison population is the result of ill-considered political decisions, with successive Victorian governments enacting harmful laws to appear tough on crime. Like so many injustices, due to a toxic combination of the ongoing impacts of colonisation, systemic racism, and discriminatory policing, Aboriginal and Torres Strait Islander people bear the brunt of this, and their imprisonment rate has almost doubled in the last 10 years. I'm a managing lawyer at the Human Rights Law Centre and have the privilege of working in solidarity with VALS, advocating for systemic reform of the criminal legal system. And in recent years, I've worked together with the team at VALS particularly closely on the topic of today's webinar. That's because stopping the pipeline of people into prisons starts with fixing Victoria's bail laws. They're some of the most dangerous and discriminatory bail laws in the country, and they regularly fail to uphold the most basic tenets of a fair and equal legal system. The bail laws are currently unfairly removing people from their families and funneling them into prisons to be warehoused on remand before they've even been sentenced of a crime. So how did we get here? Knee-jerk changes to Victoria's laws were introduced by the Andrews government between 2016 and 2018, which were intended to target the particular actions of one particular person. In practice, they've impacted women experiencing poverty and Aboriginal and Torres Strait Islander people the most. The changes to the bail laws have made it harder for people to get bail in more circumstances than before, and this is because of two key things. The first is the reverse onus provisions, which require a person to show either compelling reasons or exceptional circumstances that exist for them to be released on bail. And if a person is unable to meet the applicable legal test, then bail must be refused. The second is because the broad range of offending captured by these reverse onus provisions. Previously, the exceptional circumstances test applied only to the most serious offences. Now, if people engage in repeat low-level wrongdoing, like shoplifting, for example, they can be held to the same standard as people accused of the most violent and dangerous crimes. Together, this is resulting in more people being denied bail, not because they pose a risk to the community, but because they themselves are at risk of family violence, homelessness, economic disadvantage, and mental illness. Intersecting forms of disadvantage make it harder for women to put forward a case in favour of bail, which too often makes time behind bars the default setting. This is confirmed by the data, with data regularly published by Corrections Victoria consistently showing that well over half the women in Victorian prisons are detained there and are unsentenced for what they were arrested for. And this was very tragically the case for Gundijtmara Dhudhuroa and Yorta Yorta woman, Veronica Marie Nelson, who died in custody at the Dame Phyllis Frost Women's Prison in January 2020 after being arrested for minor shoplifting-related offences and being refused bail. VALS have been supporting Veronica Nelson's partner, Percy Lovett, through the coronial inquest into her death, and everyone should read the submissions made by VALS on his behalf, which powerfully put that Veronica would not have died and would have been at home with her family if it were not for Victoria's punitive and discriminatory bail laws. Aboriginal women are the fastest growing demographic in Victoria's prisons. And even just a short time in prison means that they risk losing their kids as well as their homes, their jobs, and their connection to the community. Many of these positive factors in life can act as protective forces against poverty and abuse are removed. And upon release, women are too often forced to start over, often on their own. The current system results in the injustice of women typically serving short periods of time in prison, on remand, and often then pleading guilty and receiving time-served prison sentences, The low-level wrongdoing that should have never have warranted a term of imprisonment in the first place, but because that's the most straightforward path to release. We imagine that innocent until proven guilty holds true for our legal system, but increasingly that's not the case. Rather than being afforded the opportunity to fight their cases from a strong position of freedom, people are increasingly forced to deal with their legal matters from prison cells while enduring the harm that's inherent in being imprisoned. Really distressingly, Victoria's bail laws also apply to children. This is part of a broader trend across the country with regressive reforms in the Northern Territory and Queensland notably that are increasingly flipping the usual process for granting bail on its head and driving more and more children into prisons on remand. Children should never be subject to reverse onus bail provisions that too often make time behind bars the default setting. Yet we are at a point where we have a criminal legal system in Victoria and across the country really, which turbocharges injustice. Earlier this year, a Victorian parliamentary inquiry called for an overhaul of the state's bail laws following its review of the criminal legal system. The Andrews government has failed to respond to that review, which it was required to do in September earlier this year, and has failed to respond to the 100 recommendations that review made for change, including that the Andrews government should review the operation of the state's bail laws. This recommendation does not go far enough, and fixing the state's bail laws cannot be delayed by any further reviews. The reverse onus provisions in the bail laws must be repealed as a matter of urgency, and a presumption in favour of bail must be created, with the onus on the prosecution to demonstrate that bail should not be granted due to there being a specific and immediate risk to the physical safety of another person or the person posing a demonstrable flight risk. These are the calls of VALS and partner organisations, and I encourage everyone to sign VALS's petition calling on the Andrews government to fix the bail laws, which is online and available at www.vals.org.au/bail petition, which calls on the Andrews government to enact that reform. And beyond this, instead of building new and expanding existing prisons, the Victorian government should be supporting more social housing and services that divert people away from the criminal legal system to begin with. The upcoming Victorian state election this November comes at a critical juncture against the backdrop of a criminal legal system in dire need of overhaul. The time to end mass imprisonment is now, and whichever party wins, they must stop propping up a system of cruelty and end this injustice. VALS and partner organisations like the Human Rights Law Centre have been clear in our calls for change. All that is missing is the political courage to do what is right and chart a different course.
Thank you, Monique, for that powerful address. We are now incredibly grateful to be able to share the experience of Amy, who was refused bail in 2019 and held on remand. Amy gave evidence to the inquiry into Victoria's parliamentary system about her experience in 2021. The recording you are about to hear is from a radio interview that Amy gave on 3CR Radio. Thank you to Amy, 3CR, and Flat Out for allowing us to play this for you today.
I'm Amy, and I have lived experience of being remanded in custody at DPFC. My experience was in 2019. There was a family violence incident between myself and my husband. He held me down and strangled me, which was witnessed by my 12-year-old son with autism, and I defended myself, which stopped him, strangling me, but the police were called and I was arrested and he was taken to hospital, and that's sort of the starting point. I had a 12-year-old son, an 11-year-old daughter, and at that time a 17-month-old baby. The last thing my son said to me before the police arrived was, "I saw him hold you down. I don't want to be taken away from you." I knew the police were coming, so I sort of kept it together as best I could. I explained at least 3 times to the police that came what had happened, and they sort of weren't interested. The argument that had happened is that it was based on money. So there was a lot of a background of abuse in the relationship, but sometimes physical, but more emotional, psychological, coercive and financial control. So this was an argument around that financial, like withholding financial assets of the marriage. And one officer at the scene was like, walked off, was like, oh, so it was an argument about money. Yes, I was arrested, I complied, I cooperated every step of the way. I, at that stage, was working within the criminal justice system, so I had a belief in the system, and so I strongly believe that if I could just tell the truth about what would happen, I would be released on bail. I expected consequences, but my first and foremost thought was I need to go home to my kids. And the police denied me bail, and then the next day I was taken to court and I waited all day, and I saw a duty lawyer very briefly who said, who I again explained all the circumstances to, and basically they advised make an application for bail yourself, and if it's denied, you have another chance to get a lawyer to do it for you. When it was my turn to go into the court, the judge said to me, there's a presumption against bail and you need to provide a compelling reason why you should be granted bail. I wasn't charged with any serious offences. I was charged with a few, like assault and things like that, but the most serious charge was intentionally causing injury, not causing serious injury. There was no serious charges. So I said to the judge, look, I'm 30 years old. I work in the criminal justice system. I have never been arrested or charged or anything in my life. This was a family violence incident where I was defending myself. I have a child with autism. I have 2 other children, a daughter and a 17-month-old baby, and if I'm not released, they will go into foster care. And that wasn't compelling enough, and I was remanded into custody. It is really hard when you've been a victim of family violence. You've, the night before, been strangled in front of your son and being taken away by police in front of your children, to get up there and coherently explain why you should be released. Like, it is, and then to have a judge say, not good enough, it is soul destroying. I was remanded for 110 days. I explained to my lawyer that I wanted to explore a defence of self-defence. My lawyer advised that this would be unlikely to succeed and that it would involve cross-examining my then 13-year-old son who has autism, and that the court doesn't look kindly on cross-examining children, and also not something that I would want to put my son through. So I followed, that advice. I pleaded guilty. I had served 110 days on remand. I was sentenced to another 10 days, 120 days all up. In sentencing me, the judge said that if not for my guilty plea, he would have doubled my time to 8 months. I saw my 17-month-old twice in 120 days. And so when faced with, you can basically get time served or serve another 4 months and not see your children, despite what I think is right and the truth of what happened to me, I think, and I know the mothers in there will do anything to get out to see their children. Aside from losing care of my children, I had a rental, I had a full-time job within the criminal justice system. Yeah, so overnight, by the decision to deny me bail, I lost my house, my job, my kids.
Before we move to our panel discussion, we're going to play a community legal education video about the bail laws that we've recorded. It's a chat between Charmaine Anton, who is our head of community justice programs at VALS, and Justine, a senior lawyer in our criminal practice team.
Hi everyone, my name's Charmaine Anton and I am going to do a welcome to country, which I am coming to you from the lands of the Wamba people with neighbouring communities of the Wadi Wadi and Barappa. Today we're going to be talking about something that's very important to the Aboriginal communities and to people here today, which is the Bail Act and the bail laws. I am the statewide community justice programs leader, and today I've got Jess here with me. I'll get Jess to introduce herself.
Thanks, Charmaine. Yeah, my name's Jess, and I'm one of the senior lawyers in the criminal law team here at VALS.
Thanks a lot for coming along today, Jess. What do we mean when we talk about remand and bail?
Yeah, thanks, Charmaine. So essentially, when someone is arrested or charged for a criminal offence, the police have options in terms of the way in which they can require them to then turn up to court. So someone can be charged and then issued with a summons. They can be bailed, or they can be, as you say, remanded. So depending on what the charge is, and also depending on whether people are already on bail for other matters or serving a sentence, will determine whether the police summon someone, or whether the police choose to bail someone, or whether the police apply to have someone remanded, so remain in custody until their court date. If that's the case, the police are required to bring that person before the court at the earliest opportunity. And essentially there's an application, which is what we would commonly know as a bail application, that's made where the police are saying that they want this person to remain in custody until their court date rather than being bailed and live in the community until their court date. So in the option where someone stays in custody until their court date, that's what we would refer to as remand. And I think the other helpful distinction is it's essentially when people are in custody, but they are not yet sentenced. So they're awaiting, a sentence.
So when can someone get bail?
Obviously, if the police bail them, that's one way that it happens. But I think a lot of the questions that people often have is around when the court can grant bail or not. Essentially, bail is granted by the court if the tests that are set out in the bail laws are met. So for some offences, the only requirement is for the court to determine whether someone is presenting as what in legal terms we say is an unacceptable risk. So sometimes that's the only question that the bail decision maker, which in this case would be a magistrate, would have to consider. In other circumstances, and again, this depends on what people have been charged with and whether they're already on bail or serving sentence. So there's different kind of categories that people fall into. And the first of those is what we would call compelling reasons. And there's also a second category called exceptional circumstances. And so depending on which one of those people fall into will determine what essentially needs to be shown to the court to prove that we meet that criteria. So when the bail application is being heard, the compelling reasons and the exceptional circumstances are the things that are addressed first. And that's something that has to be addressed by the accused person or their lawyer on their behalf. And so it's essentially what we would say, it's our burden of proof is the legal term, but essentially it's our responsibility to be able to show the magistrate that we meet that criteria. And that will cover a range of different things, including whether people are Aboriginal or Torres Strait Islander, but a range of other things like mental health concerns, drug and alcohol, other health conditions, and also things like whether they've got supports in the community, what sort of family support they've got, connection to culture. All of those things are considered when the magistrate is determining whether they think that there are either compelling reasons or exceptional circumstances that this person should not remain in custody for the period of time that they're waiting for their matters to be heard. And if those things are satisfied, then the magistrate then also still has to consider whether they think that the person is an unacceptable risk of being released into the community. And essentially that's what the police are responsible for, putting forward evidence to prove to the magistrate or to persuade the magistrate that this person is going to be considered too much of a risk to be in the community while they are waiting their court date.
When you're talking about questions around what would help with their bail, if somebody was carer for their elderly parent or aunt, would that be something that would be taken into consideration too, Jess?
Yeah, it absolutely would. And I think one of the things that's really tricky in answering these questions, and I think for anybody that has had conversations with lawyers around bail themselves or someone who they know is in that situation, often the lawyers will say that depending on the circumstances will depend on the weight that's given to those things. So things like what you've mentioned is absolutely going to be considered, depending on a range of other factors, including like what they're charged with and other circumstances. It will be weighed against the other factors. But I think probably the really important message for people to know is that it's having the information is the most important thing. Because if I'm the lawyer and I know that, then I can put that in the kind of the mix of all of the things that I know and present that to the magistrate for them to weigh up, you know, the significance of all of those things. But if we don't know that, then obviously, you know, we can't kind of provide that information. So I think it's better for us to have more information about what's happening in people's lives, and then we can kind of figure out, the weight to kind of place on some of that, if that makes sense.
Yeah, definitely. Thank you for that, Jess. When people are taken into custody, what should they do?
Yeah, so I think if anyone's taken into custody for questioning, they will be given their cautions and their rights. So most people would be familiar with these things, which include being able to speak to a lawyer, being able to let someone know where you are. And people will always be asked as well whether they are Aboriginal or Torres Strait Islander. And what happens if people do identify as being an Aboriginal or Torres Strait Islander is that VALS is notified of that. So every person that goes into custody who identifies as Aboriginal or Torres Strait Islander, there's a notification that goes to VALS, and there's a dedicated team of people who will then make sure that we're checking in on and making sure that the wellbeing of people in custody that we're aware of how they're going. And also, I would always suggest that people take the option to speak with a lawyer just so that they can get some advice about the pros and cons, essentially, of making comment to the police, and just even getting information about what's going to happen, what's the process. So I think that they're the things that are probably the key kind of things to remember if people do happen to get taken into custody.
Definitely. Do the bail laws apply to adults and children?
Yeah, they do. So the Bail Act applies across the board to both adults and children, including children as young as 10 years of age.
Thank you for that. How is someone's Aboriginality taken into account in bail hearings?
There are specific provisions in the Bail Act that require that people's Aboriginality is taken into consideration. So there's a specific section, Section 3A in the Bail Act, that is only about that. Is all that section talks about is that when making a decision about whether someone should be granted bail, if they are an Aboriginal person, then that must be considered, and there also must be consideration given to their connection to, or just their involvement with, culture and family and the things that are obviously incredibly important for them. So that's one way, in that it is legislatively required. And the other thing is that there's a further section in the Bail Act that talks about when considering, and this is for any person, when considering a bail application, that the magistrate has to consider what we would call their surrounding circumstances. So that's all the things we were kind of talking about earlier in terms of people's personal circumstances, any like health and wellbeing issues, anything like that they might be dealing with. But people's Aboriginality is absolutely to be considered as part of that kind of consideration as well. So those provisions were introduced in 2010, and really just to make it very clear that there's an explicit intention to reduce the over-incarceration of Aboriginal people. I mean, there's probably a whole other conversation to be had about whether that's been successful or not, but that's kind of obviously the intention of it, specifically including that in there. I think one of the things that we often see is a conflict between people's bail conditions and, say, sorry business, for example, and because people have static addresses and curfews and other things like that make it really hard for them to engage in sorry business. And so the Act does require that those things are considered when bail conditions are being put in place.
Thank you so much for coming along and answering those questions, Jess. Really do appreciate it. One thing that I can strongly recommend is that if anybody has any questions for Jess and our amazing team at VALS, please contact us. If there's anything that we can answer, we're very happy to answer. Or if there's a team at your organisation, we have our community legal education worker who will be very happy to organise for an education session with you guys. So give us a call. We're here to help and strengthen our communities to make them more resilient and stronger. Thank you.
Thank you to Charmaine and Jess for giving us a brief overview of how the current law works. We're also really grateful to be able to share the experience of Uncle Percy Lovett, who lost his partner Veronica Nelson in 2020 when she was detained on remand at Dame Phyllis Frost Centre. Uncle Percy gave his permission for VALS to share some extracts from his written submissions during the inquest.
Veronica and I were together for over 20 years. We did everything together. When we first got together, I told her no matter what, wherever she goes, I would follow her to the end of the earth, no matter where she goes. I loved her very much, and I am missing her that much I don't know what to do with myself. Veronica was a very strong woman. She was also a very brainy person. She taught me so much about our culture. Whenever she would talk about black fellas, the stories she would come out with were unreal. She knew a hell of a lot more than me. She really woke me up and made me listen. On the day she was arrested, Veronica was at home with me. I remember her leaving home in the morning. Then one of her brothers came and told me she had been arrested. After I heard that, I went to court the next day to check if she was in court. I know that people are usually in court the next day after they are arrested. When I arrived at the courthouse, I looked up on the board to see where Veronica's case was and went to that courtroom. I was in the court when Veronica applied for bail. When I saw her in court, I noticed that she was looking sick. I could tell from her body language. That's why after her case, I think I yelled out to her, "Make sure you see someone in the jail." I think that magistrate had already made up her mind before Veronica even started talking. I could tell that she'd made up her mind. When Veronica said that she was representing herself, that tripped me out. Why was she representing herself when she had breached her bail conditions? Some of the questions that the magistrate asked, Veronica didn't even know how to answer. The magistrate should have known what questions to ask. The magistrate should have known why Veronica asked for 6 weeks so that she could be put on the methadone program. She should have known that. Veronica said she didn't want to go to Shepparton for medical reasons. The magistrate didn't even give her a chance to explain what that meant. I don't know why that lawyer in the courtroom didn't represent Veronica. Veronica would have been really upset and sick. He should have represented her. I don't know why they didn't just adjourn the matter until Veronica could get a lawyer. I read that the lawyer who was meant to be representing Veronica said she was aggressive. I don't think Veronica would have been aggressive. She's not like that in court. When she gets upset, she doesn't let anyone see how she gets upset. I've seen Veronica speaking to white people and people in authority. She would respect what position they were in. She was quiet. She doesn't get cheeky. She doesn't get smart. She basically says what they ask her to do. She was always well-mannered. People in authority and that, she doesn't get cheeky with them. She was quiet but voiced her opinion when it had to be voiced. Veronica was my other half. We did everything together. We had plans for the future. Even now it spins me out how much I miss her. I walk downstairs and I still expect her to be walking around the corner. I loved her very much and I'm missing her that much. I don't know what to do with myself. Veronica was always helping people. She would help people if she saw them in the street. She always made sure you were well off, that you had everything you needed. If you didn't have it, she would go out and get it. She never knocked anybody if they needed help. Veronica shouldn't have been in prison. She shouldn't have died.
Hopefully you found those videos to provide a great foundation for us to now launch into our panel discussion looking into more detail the impacts of the VALS system. We're incredibly fortunate to have a great panel to discuss these issues, as well as multiple testimonies from individuals with lived experience of the bail remand system. Michael, thanks for being part of the webinar today. Let us know a little bit about yourself.
I've been taken back a little bit there from Uncle Percy's words. We played a bit of footy together, me and Percy at Fitzroy Stars, so I have a bit of a connection with him through that and family as well. All right, so let's start with me, I guess. I've been working at VALS as the CEO for the last 6 years. Previous to that, I've worked at VACHO, which is the peak body in Aboriginal health. I've worked at VACA in child protection, VAI in Aboriginal education, at Fitzroy Stars Gym when it used to be around. I used to be the sports coordinator and youth worker. And I worked at VALS as what originally was called a field officer many years ago, and then came back as a client service officer a little bit later, which got me to answer those calls in the middle of the night. But also every Wednesday I would go into the prisons, particularly Port Phillip. Well, in the early days it was Pentridge, and then later on it was Port Phillip and to the women's prison as well. Women's prison was scary for a young man, but the men at Port Phillip and Pentridge were, and I tell this to everybody, were the nicest people you could ever meet. They always made you feel welcome. They wanted to have a yarn and everything like that. My wife and I have raised 10 children, 23 grandchildren and one on the way. I just found out 2 weekends ago. So I come from a fairly big family and been a part of the Aboriginal community in Melbourne pretty much all of my life, and got to see a lot of things, I guess. I was talking to Bonnie earlier because we was just in a meeting, and I said, I haven't prepared notes, but just everything that I already know, the experience and everything through life and working in the different sectors, I've been able to gain a lot of knowledge. So I'm really happy to come and share that knowledge with you. And I'll leave that as me for now.
Thank you, Michael. Your substantial experience over the course of your life will certainly, I think, hold us in good stead to have this conversation. Next up is Bonnie Dukakis. Can you tell the audience a little about yourself, Bonnie?
Thanks, Narita. So my name's Bonnie Dukakis. I'm a proud Gundijtmara woman. Grew up on Gunnai country down in Gippsland, and now living and working on Wurundjeri country, and also just like to acknowledge country and that I'm fortunate enough to work on, but also acknowledge the grief and loss in our community at the moment. I'm coming to you as the acting executive officer for Koori Youth Council, and been working with KYC for the past just over a year now. But prior to that, I've had 8 years working in the justice space, from on the ground in community corrections in residential facilities, but also in custody in Parkville and Malmesbury, and everything probably in between, and excited and thankful for being part of the conversation today.
Thanks, Bonnie. And finally, our very own Kin Leong. Can you introduce yourself?
Sure. So great. My name's Kin Leong, and I joined VALS in 2014, and I've been the principal managing lawyer of the criminal team since 2017. So I've seen firsthand what these bail changes have done, and the damage that they've the damage it's done to the community that I represent. So looking forward to the conversation.
Thank you, Ken. So I'm going to address each question to one of you to start with, but after that, just let's go from a conversational approach. So jump in when you want with any contribution you would like to make. And the audience, please do not forget to put questions in the Q&A box in case our wonderful speakers run out of things to say. And then you can pepper them with questions, which I'm sure you all have. So first up is Kin. The current VALS system in Victoria is often regarded as punitive. What does that actually mean, and has that always been the case?
Well, no, it hasn't always been the case. In fact, when I started practice, it was very much, bail was a much broader presumption in favour of bail, and it was more of a risk assessment, and basically to ensure someone's attendance at court, if there was a real risk of harm to the community or a risk of reoffending, and not just any reoffending. It really was a focus on reoffending that was harmful to the community, so be that violence, or mainly acts of violence. But now, since 2018, the changes have seen a really sharp tilt towards, they would say, protection of the community, but very much, I would say, perception of protection of the community. So the reforms were really, really heavy-handed, and basically it's created 2 reverse onus tests, which are really tough for not only lawyers to navigate, but as what often happens in court, unrepresented people are potentially the most vulnerable moment of their life, to try and navigate these 2 reverse onus tests, meaning it's much, much more difficult to obtain bail. So how is it punitive? Well, it's, as was mentioned in the previous videos, there's no doubt that even short term of imprisonment, incarceration can have a really damaging effect on someone's life. It can lead to a loss of housing, can disrupt treatment that people are accessing in the community. It can result in loss of employment, and possibly most importantly, it really breaks a connection with family, people's children, and any supports they have in the community once someone goes into custody. To give you some idea of just how much the incarceration rates have increased since these changes, and we're talking about incarceration rates of people that are unsentenced. So these are people not convicted of any offences that find themselves in custody. So 50.5% of the Aboriginal prison population at the moment is on remand. That means unsentenced, not convicted of those offences, compared to, prior to the reforms, 32%. So it's a really, really profound and sharp increase in the incarceration rates. And of course, we already heard the really disgusting statistic that 58.5% of Aboriginal women in prison are unsentenced and just on remand. So these two high threshold questions are for bail. So one, having to demonstrate exceptional circumstances, or having to demonstrate compelling reason as to why bail should be granted. These are really complex tests, even for a trained lawyer to navigate. So you hear the terrible and really distressing evidence of Uncle Percy, that someone in a really vulnerable position needs to overcome these tests without the assistance of a lawyer. I mean, it's almost an impossible task, and so the presumption is that someone is going to go into custody. The other problem is, of course, is it soaks up all of a number of offences that are either not violent or low-level offending. So I'm talking about something as innocuous as a shop theft or possession of a small amount of cannabis. All of these can lead to a situation where someone needs to demonstrate exceptional circumstances to obtain bail. A threshold previously only applied to people with the most serious offences, and I'm talking about the most serious: murder, treason, high-level drug cultivation, like really, really serious offences. Now we're finding someone who, perhaps, through a whole series of events, might find themselves on their 3rd shop theft, having to demonstrate the same level to get out on bail as someone who's being accused of murder. It's a disgusting, shocking system, and there's no doubt that it's punitive, and it's really causing great harm and damage to the Aboriginal community.
Can just follow on from that. I mean, you've been with VALS for quite some time now. Let's not name years. But would you say that those serious offenders are probably the exceptions and not the rule when it comes to your criminal practice?
Yeah, absolutely. I mean, anecdotally, from my experience, A lot of our bail, it's very rare that well, first of all, I'm not doing a bail application generally for people charged with terrorism offences. And certainly murder, where people are being accused of murder, that is thankfully a very infrequent bail application. And in fact, it's an offence we generally don't make a bail application on because the threshold is so high. So yeah, I would say that certainly a bulk of our bail applications now fit within one of those two categories, being exceptional circumstances or compelling reason. And a lot of the time, it is for what could easily be classified as really low level and non-violent offences.
Yes. I mean, I think if I look at our data for the last 6 months, it probably won't surprise you that about 1/3 of our criminal practice matters relate to drug possession.
Yeah.
And then you've got shop theft after that, and real petty offending, and certainly those higher offences are rare.
Yeah.
Bonnie, we've heard earlier that the bail law applies to adults as well as children and young people. To your mind, what is the impact of holding children and young people to the same test as an adult?
Thanks, Narita. So I guess firstly, I think it's alarming to see that we can see our children and young people being subjected to being able to demonstrate the same need, whether it's under exceptional circumstances or compelling evidence. And what we've seen in the last few years, so in 2021, the Commission for Children and Young People did an inquiry, Our Youth Our Way, looking at the overrepresentation of Aboriginal and Torres Strait Islander children and young people in Victoria. And they were alarmingly overrepresented in many spaces of the youth justice system. So looking at not just pre-sentence, so looking at bail applications and supervised bail, but also looking at how that was impacting them on remand. And I think wanting to highlight that there's limited access to services and supports for someone who is pre-charged. So as we know that they haven't been found guilty, or they're at this point still accused. So their level of access to supports, whether it might be for substance use or whether it might be transient with accommodation or a whole host of things. So being able to access the supports that they might need doesn't come at that point. And I think that's where we need to relook at how do we ensure that we can have systems that work for our children and young people that I guess make them stronger and strengthen them to not grow up entrenched in a system. I think the other part and things that I've seen alarming is the growing number of remand, but also in Victoria we have what we call the dual track system. So you might have a young person aged between 18 to 22 that could spend 6 or so months on remand in an adult prison, so in your Port Phillips or your Ravenhall, and then get sentenced back to youth justice and have a different level of access to supports that they require. And I think that real targeted, like the need for a young person between those ages, between 18 to 22, is quite different for an adult that's between 30 or up, what supports they need. And I think all of the stories have touched on it as well, and the lived experience of particularly like the children and the impact from parents that have been incarcerated and how that plays out. And I think the other thing is looking at I think we can't talk about children and young people in this space without talking about the crossover in the system. So we know a lot of children and young people that might be involved not just in youth justice system for whatever reason, but also in the out-of-home care system, whether that's in residential care or foster care arrangements or a whole host of things. And we see that sometimes it's actually child protection that are opposing bail and looking at what their role and function is, and being as a good parent would, how can you think that being in custody is a safer or better option for any child or young person than being at home, being cared for and being able to be supported to address whatever needs that's underlying their offending. And I think, being able to understand what's driving it, and we look at what alternatives can we have for custody that's not being remanded if you're being bailed, to looking at like community-led facilities. Like you've got a couple out there, like you've got Bunjawara and you've got Baroona and you've got those spaces, but something specifically for our young women, and also something that I think we need to revisit and look at how that, not saying that and acknowledging the low level offending, I think, is the key part, that we're seeing a lot of young people that are remanded not for the more extreme end of offending, and that what we see is, talk about it more broadly in community, that's kind of the community perception that it's all these very violent young people. I'm not discrediting that there is violence, but also we need to understand the underlying factors and what more supports can be in place. At the end of the day, they're still children, young people, and we need to make sure that we can support them to thrive in their communities and not, I guess, get entrenched in the system.
Thank you, Bonnie. Michael, what are the potential implications from a health perspective if someone is incarcerated on remand or rather than being released on bail?
Yeah, I guess first, and not knowing who the whole audience is, understanding what Aboriginal health is first. So it's more than just the primary care, it's the emotional, spiritual, social, emotional well-being of a person. And so I think Kin mentioned before about the effects that as soon as somebody's taken out of the family makeup, it affects the whole family. And then therefore, in the way in which we as Aboriginal people live and work together, it affects the whole community. So you take one person out of that picture and it affects the whole community. Now, when it comes down to the personal side of things, 75% of our people have a chronic illness. 50% of them have more than one. And so when you're dealing with that on the outside and you get taken away from that, all of a sudden you lose that support. And we know from people telling us who have been incarcerated, whether it's short-term or long-term, is that they're not getting the appropriate care from the moment they walk in the door. You know, think about most of our people, one of the main chronic illnesses is asthma. And as we know, that tends to get associated with smoking. We can't smoke in prisons. So you're looking for, you know, that's an effect already, because people often use smoking to be able to relax rather than always just, you know, as a habit. It's a form of relaxing. So I guess from a health perspective, you can go through a whole gamut of different effects that's going to have. Diabetes is another one. You know, you need insulin straight away, and that kind of care doesn't come quick enough. Talking to somebody who's been visiting the women's prison a couple of years ago, and she said the women aren't getting pap smears, they're not getting breast screening, things like that. All of these things have an effect. And then you've got the people and the families on the outside going, well, you're not getting that care. Now I'm stressed because you're in there and you're not getting that care. It has this flow-on effect throughout the whole community. What we do know, and I think you've touched on a little bit, a lot of these crimes are poverty crimes. And, you know, our mob are battling systems that don't address their needs as it is. You know, we're always trying to be, government's always trying to assimilate us. And they might have said we got rid of the assimilation process, but these systems are built for assimilation. And this is why we have ACOs and ACHOs, community controlled organisations, so that we can look after our people the way in which we know that they need to be looked after. They also have trust and confidence in our organisation, so that way they come to us more. They listen to what we've got to say more. There's that confidence. So I could probably go on a whole range of things, but just that immediate care, if you can get that as soon as you walk in the door, at least that's one thing off your mind. Because how are you supposed to be thinking about your court case if you're worrying about your health? How are you supposed to be thinking about your court case if you're worrying about the effects that you being taken in there, the effects that's having on your family? You know, who's going to look after my son, daughter, my wife, grandparents, whatever it may be that you've been doing on the outside? So it becomes a bigger issue than just the primary health. There's that whole wraparound service that we all do for our families, and each of us have a role to play within our families, and that role also extends to our communities. So it becomes much bigger than just whether I need a smoke or not. It becomes much bigger than that. The stress levels go crazy on the individual, but that flow-on effect.
Thank you, Michael. Ken, over 30 years ago, rigid recommended imprisonment should only be used as a sanction of last resort. Obviously, this hasn't been occurring. How does the Bail Act impact sentencing?
Yeah, Narita, I think so. The bail changes have a really potent effect on sentencing. Probably first and foremost is the ability to successfully defend yourself or defend a case from custody is much more difficult than if you're in the community. But also some of the other things that we've been talking about, that immediate interruption to treatment, rehabilitation, engagement with programs, all of these things which are great sentencing factors when someone's receiving a sentence, and these issues of mitigation, while you're in custody, while you're on remand, you have very, very limited access to any of these programs, making it very difficult for you to make any kind of mitigation submissions in a sentence, particularly when you're conducting a plea. It also, you're more likely, I would argue, to receive a custodial sentence if you're on remand, if you're appearing from prison, either that by virtue of receiving a time-served sentence, which we've already heard the heartbreaking story of Amy, or you're less likely to receive a CCO. And I would argue that there's generally no positive benefit to criminal justice involvement in anyone's life. But if we were to be generous and say that there was some benefit, access to therapeutic court-sponsored programs through CCOs is potentially one, but someone's already done time in imprisonment, so the ability to get a CCO is somewhat limited by the fact that someone may have already done more than enough punishment or more than enough time to warrant a further CCO, but also difficult to say that someone's suitable for a CCO if they haven't been able to demonstrate that they've been accessing programs and community supports while they've been in custody. That's backed up really, but if we look at from VALS's point of view, there's been a sharp rise in custodial sentences. So post the bail reforms, there's been an increase of 24% of custodial sentences handed out, as opposed to pre-bail reforms, where it was 17.9%. Also, probably the most distressing thing is we heard also in Amy's story that refusal of bail does actually encourage guilty pleas before there's been any ventilation of the veracity of the charges, the standard or quality of the evidence that can be used against someone accused of a crime. That basically, while someone's in custody, there is significant disadvantage to defend themselves and therefore are more likely to put their hand up, plead guilty to an offence which perhaps they shouldn't be pleading guilty to, simply because they're in custody and will continue to remain in custody until their matter can be heard. So in this situation where Amy is really, her commitment and need to be back with her family really sort of drove her to a situation where she's pleading guilty to an offence when really she shouldn't be. Also, my personal experience, previous terms of imprisonment also result in a more likely that you're going to receive a term of imprisonment when you're before the court again. So if you look at someone's set of priors, and which is also part of the sentencing process, we see that someone's been in custody before, they are more likely to receive a term of imprisonment when they're before the court again. And without proper investigation of why that previous term of custody is there, then there's no way that it makes it very difficult to argue that they shouldn't be receiving a term of imprisonment when they're back before the courts again. Yeah.
So naturally, Ken, the next question is, well, how do we fix it? What reforms do we introduce to ensure that the bail system complies with rigid recommendations and is only using it as a sanction, using imprisonment as a sanction of last resort?
Well, I think unquestionably there needs to be a complete, the reverse onus tests, they need to be completely jettisoned from the system. They are unfair and really leading to this situation that we find ourselves in now. I think that part of it also is to really need to explicitly require that a person who's unlikely to receive a term of imprisonment should never be remanded. So the situation we've got at the moment is someone is being remanded. They'll sit there in prison waiting for sentence for an offence that ultimately they wouldn't have received a term of imprisonment for. That situation needs to be fixed immediately. No one should be in custody charged with an offence that they're very unlikely to get a term of imprisonment for. Bail must be an assessment of risk and only risk, and making out that argument for risk must rest with the prosecution, the people bringing the charge. And that risk should be real. It should be an immediate risk of physical safety to another person. It should be a serious risk of interfering with a witness, and a demonstrable risk, demonstrable flight risk. It absolutely must be a question of risk. This charge-driven idea that we can assess someone's suitability for bail, it is punitive, as we've discussed before, and absolutely we need to return bail to what it is, and that is, in my argument, purely an assessment of risk. Also, as we've seen in the really tragic case of Veronica Nelson, that there needs to be an absolute unfettered availability for legal representation whenever a court is considering removing or depriving someone of their liberty. There needs to be a lawyer in the room, and a lawyer needs to be able to stand up every time and really make sure that all the issues are ventilated before the state, in our name, deprives someone of their liberty. That needs to be the cornerstone of the system, I think. And I think also a better understanding of 3A and running alongside 3A is it can't be a cursory assessment. I would say that every bail decision maker at every level, be it a bail justice, a police officer or a magistrate, not only consider 3A, but document and say in open court how they've considered 3A, how it's been used and how it's led to their decision to either refuse bail or grant bail. But 3A needs to be a real consideration, and training in 3A and needs to be ongoing. It needs to be robust. It needs to be presented by First Nations people. It has the control of 3A and the training people receive on it needs to come from Aboriginal organisations, and it needs to be led by First Nations people, and it needs to be ongoing. It can't just be, oh, congratulations, you've become a magistrate, here's your cultural awareness training, here's something on 3A, 20 years later you've received no further education. It needs to be ongoing, and it needs to be constantly updated, and bail decision makers need to be reminded of 3A and what it means.
Thank you, Ken. Bonnie, on top of what Ken's discussed in terms of reforms required, in the case of Aboriginal children and young people who may be accused of an offence, are there additional reforms or initiatives that we should also be thinking of?
I think for me, like the simple, I say simple, but I talk about Nuggagy. So Nuggagy was a report that KYC did around talking to young people that were in the system. So they spoke to 41 young people that had been involved in the system and came up with kind of ideas on what young people were telling us on what they wish they had access to or what they wanted to do. And it's not the pretty end of things, because we look at the responses now are so, as we say, punitive, and it's all around that reactive response, and that's essentially saying you can't say the system's broken, because we look at that's exactly how the system was built and what it was built for. We need to have early intervention and prevention programs. We need to make sure that we're creating opportunities for young people, our children, to have access to this before being in custody. I think Ken touched on it around CCOs and being able to, like a community corrections order where you can direct someone to attend rehabilitative programs, whether that could be behaviour change, whether that could be access to drug and alcohol support. And it shouldn't be that case. We need to be able to empower our people to take those steps before. And I think particularly when we talk about our young people, one thing that came through clear was as simple as giving children services at work, ways that they can have their voice heard throughout the process, that it's not waiting until everything's gone wrong in this young person's life that they come to a point where they might be remanded for something, and looking at where everything's gone wrong, how can we ensure that we build them up to be strong in their culture and their identity before it gets to those points. Keeping children safe and strong in their culture and families, community designed and led youth support systems. So a lot of the time, and that's why I think so unique with KYC, where we get to have that position to ensure that young people's voices are heard, in decisions that impact them. And we hear that consistently around how do we give young people a voice. And I can tell you, anyone that's worked with a young person, they'll give you their voice and they'll give you their thoughts on what they want to see and how things should work for them in a way that best fits them. But often that's not challenged, or they're not having those opportunities to be heard, especially when it comes to decisions around bail and whether or not what kind of sentencing indication. I've got ads working with young people in the system, that they know the system better than anybody, and they could sit there and they can know, depending on what charges they've been accused of, on what their sentencing indication would be. And there's a strong push with some that would turn around and go, I know that I'm not going to get a custodial sentence for this offence, and this is what I will get, or this is what the likely outcome will be. And then to find out, once they do go to court and they front court and they do get released or they get bailed, that how come that hadn't happened earlier? Like, it has to wait until they're in the system, which is further entrenching them. I also think Amy's story touched on it as well, and her views as someone that's worked in the system, and that she had faith in the system that it would do the right thing. And then we hear of like the attitudes that we work so hard with Aboriginal people that have been impacted by the system to understand what they're there for, and that they are here for us. And then I've worked with someone 6 years ago that had been on an order, completed their time and done everything. And then 6 years later, something's come up because of their history over 6 years ago. They've been remanded without bail. They've lost their job. They've lost their house. And they've lost everything that kept them strong and safe. That it's actually backflipped on their perception in community. It took them so much time to be okay. We've seen the Junga, seen the police down the street and go, they're just doing their job, to now back at a point where they can't stand to see them and they're just feeling on edge because of their experience. And we don't want our young people to feel like that. We want them to feel safe. We want them to be able to access services and supports that they need, and not, I guess, feel like, that they're doing something wrong if they do. And we want to be able to encourage them. So that's probably a little roundabout way, but I think that's just a couple of little ideas.
Not little ideas, Bonnie. I think fantastic ideas, and certainly I agree with you that that fear of institutions and policing really kind of impacts upon community being willing to go for the help. And then you see the victim cycle being entrenched. And we already know that Indigenous women particularly don't tend to report family violence 90% of the time, which is horrifying. And you can imagine that includes other offences which create real trauma and impact upon community. Michael, under international human rights law, everyone has the right to the highest attainable standard of physical and mental health, and people who are incarcerated should enjoy the same standards of healthcare that are available in the community. Is this the actual case of people who are remanded in custody in Victoria? Would you say that they're getting the same standards of healthcare that are available in the community?
Short answer is no. And
answer?
We know from those who have come out of prison, we know from talking to people who have been in prison, who are visiting in prison, that their loved ones aren't getting looked after the way they should be. And this has been going on for a very long time. I mean, you look at those who are governed by private institutions, they're from overseas, UK, USA. What do they know about Australia, let alone its First Nations people? The care that you get walking into an ACCHO is totally different to the care you get walking into a mainstream organisation. Now you're going into a place where you're stripped of all of your rights. You can't even claim Medicare or anything in there. And you're getting looked after a lot of the times by some mob overseas who are subcontracting to others here. So the answer is no. We also know that if you look at the deaths in custody, that it's not getting any better. You know, it's been a long time since we did that Royal Commission into deaths in custody, and you know, there's still over 500 people dying since. So the rates aren't getting better in that area as well. So yeah, that's pretty much the short and sweet of it. No.
Certainly. I mean, if we reflect back on Rickadick, which started before I was actually even born, they examined 99 deaths, 11 were women, but the prevalent cause was lack of healthcare, adequate healthcare service provision, and nothing has changed. If we look back at, the last 3-4 years in Victoria, we have had such a big increase in deaths in custody, and all of them have concerned healthcare provision. And we also saw that during COVID, and it was great that we had VALS providing that helpline and that mental health support, but we still saw a 75% increase in Aboriginal people engaging in self-harm or unfortunately taking their lives. And that's something that's touched all of our families, I believe, and been quite horrific. So it's certainly horrendous. This is still going on, and that, Michael, your mum was probably having the same conversations that you're having now, and your children at this stage are likely to have the same. And it's horrendous, particularly when there is such good healthcare provision models in ACCHOs. I mean, it's incredible the work that ACCHOs do, and my family particularly has benefited from that, and having that holistic healthcare support and that wraparound support that went beyond just healthcare but into social and emotional wellbeing and familiar support. And it's horrendous that our people in custody can't get that, particularly given the prevalence of, chronic health illnesses, but mental health and disability now also on the rise.
Yeah.
But we've talked a lot about the problems, Michael. The hard part is the solution. So how do we actually increase access to culturally safe healthcare for people who are in custody, and even particularly those who are on remand for those short stays?
The answer is quite simple. Let us do the work. Put Aboriginal health in Aboriginal hands. We've been talking to Woononga Medical Service in Canberra, and they look after the Aboriginal prisoners within their prison. Their prison is a male and female prison, and they offer a service in there. And they are seeing huge effects in a positive light. Things are changing up there. We're also doing it up in Darwin at Danila Dilbar, particularly around the youth area. But huge changes. People are actually starting to see a change in the health of the individuals in the prison. There's also, part of that is that continuity of care. So as people come out of prison, they're getting the same care when they come out. I was talking to an uncle 2 weeks ago, and he was struggling with one of his nephews who'd just come out of prison. He said, Mick, he went in there, he was addicted to one drug, and he's come out and he's addicted to another. And that other drug, he can't get on the outside. And so, this happens all the time. This continuity of care needs to happen. ACCHOs, particularly ACCHOs, look after people. I mean, we used to call it the birth to death philosophy, but it's actually before birth. It's, whilst women are pregnant. So we're looking after the women, the family, whilst the baby's still in the womb. And then once people pass on, we look after people who are mourning and things like that. So it goes actually beyond birth to death. That kind of care should follow your life wherever you go. You should know that there is support mechanisms that are going to help you whilst you're pregnant, right through to every stage in your life, whether you end up going through the prison system or not. It doesn't matter. You should still get that same care. That's what that human rights thing's all about, getting that kind of care all of your life, before you're born even. But yeah, short answer, really simple. Put us in the prisons. We'll look after our people if that's what they choose, because we always make sure you've got a choice. You can come to us, or you can go through the mainstream system. And it's not that difficult.
Perfect. And I think just to clarify, Michael, I'd say you want us to put your services in prison, not you in prison.
Exactly. Yes. I'm not really good at GPing, but I can advocate well for them. But yeah, the main thing that they told us in Canberra is make sure that you're a standalone clinic in there. You can't be governed by the mainstream, because then they start pushing you to run their side of their way of doing things, their model. So you've got to make sure that you go in as a standalone. You can still work closely with them, but make sure it's a standalone. And it's got to be, you know, people who are in prison have to have access to you 24/7, because being unhealthy doesn't just switch off at 5 o'clock. So you've got to make sure you've always got some kind of care there for you all the time.
Great.
That's whether it's short-term, long-term, mid-term, you know, in the jail cell, you know. Not only contact VALS, contact your local ACCHO, you know.
For sure. And now we get to move to the questions portion from the audience. So the first question for the panel is from Alison Thorne, which is, in the view of the panel, how can we build a mass movement to a system that First Nations people, women, people with disability, homeless people, and those who are poor can believe in?
I might jump in there first before anyone else, but I think Mick touched on it as well, around the continuity of care is so important, and choice in access to services. So we look at, like, how can we have someone that's in a custodial setting not have the same level of care or access to healthcare as they would in community? Like, I don't think that's highlighted enough. And even if it's something minor, like, how can we ensure that our community feels safe enough to even bring up their concerns? So I think that in itself is pretty self-explanatory, that we ensure that the systems in there are built up, that First Nations people are leading it and controlling it. I think Mick said it's not an add-on, it's not a second thought, that it's actually at the forefront of the discussion and the accountability, because as community, working with community, we know we're accountable to our community, and how do we ensure that the systems that are already set up, who are they accountable to?
That kind of segues nicely into, I think, a complementary question for you all to consider, which is from Mark Gordon, which says that there seems to be two streams of strategy, activism and calls for change. One is for reform and the other is for transformation. And he's noticed that some groups focus on one or the other while some utilise both. Do you think that the reforms that we've discussed today will address what has always been a racist project, upholding ongoing colonial genocide? And do you think that systems that rely on violence can ever actually be reformed?
I think we have to believe they can be. Whether they will be or not, in my generation, I don't know. But if we don't believe that we can make the changes necessary, it's not going to be good for anybody's health. So there has to be that level of hope. It means quite often that we have to continue the fight that we've been fighting. VALS will be 50 years old next year, and it only started because our people weren't getting any care at all. We're the oldest health service in this state, the second in the whole country. And same with the other places, Redfern, Brisbane, Aikes, we all had to start because nobody would see our people and look after them. So I think, if there's a belief and if we can get behind one another and support each other, we can make those changes. I will also say that some of the changes I've had to make since being the CEO, I've had to learn really quickly that just by gathering data and case studies and going to the department and saying, hey, this is what I need, doesn't necessarily mean I'm going to get it. But I can't wait because, like Bonnie said, we're accountable to our community and its needs. So there has been some things I've just had to go out and start. And if you have a look at the clinic that we have in Epping, it's received no funding from Commonwealth or state, but we knew it was needed. We had to have one out there, and it's actually too small for what it needs to be now. It grew so quick. We've got 9 consult rooms there, and we're overflowing already. Our waiting list is starting to get big. So it just shows you, if you give people a choice, they will come to where they want to go, and the ACCO sector is where they want to be. But can we change the reforms, which is the problem here? We just have to believe. But it means that we have to continue fighting for that change. And the more people who get around that, the better, I think.
Yeah, I agree with you, Michael. And I think we've seen some things that we wouldn't have expected. We've got a First Peoples Assembly here in Victoria. We now have a treaty framework that's going to inform negotiation of treaty between Victoria and state and, of course, Indigenous people within the state of Victoria. So those are things that you really wouldn't have thought of happening at this point in time, but they have. So if you can win hearts and minds, I think you can. But really, it's about making sure, I think, that we are talking to community. We are going outside of our normal wheelhouses and our little silos and having broad-ranging conversations to make sure people are aware of the issues and therefore they can use their vote accordingly to force change, because at the end of the day, your politicians are supposed to represent you. Groundbreaking, but that is what they're supposed to do. So I think look, the positive side of me wants to believe that we can change. The person who's been sitting in this seat for what feels like far too long already feels like I'm a little bit tired and worn out, and I wonder exactly what does it take, but hope must persist. So we have...
Narita, can I just say that those things are fantastic, really good. You know, we're happy to see those changes. Your rook, the truth telling, all of that, it's really great. But how much investment have they put into the ACO sector itself? Because we're not seeing it in the health sector. We're not seeing that investment. We're seeing it into hospitals and community health services, but not into the Aboriginal sector. So whilst they're doing great work in one area, don't leave the rest out, because we need that support too.
Yeah, I think a lot of that, I think, has to do with what you see as a very narrow definition of self-determination within Victorian state policy. One that I think favours and has favoured state actions and state investment in mainstream organisations rather than actually in Aboriginal self-governance. And I do hope that as we make these progressive steps and we have a more willing federal government in some spaces, that we can really tackle what does self-determination actually mean to us as a community, and therefore how do we want government to then act in accordance with that. And then I think that's then, Michael, where we actually see those big substantive changes, particularly in perhaps the way that we actually look at how the legal system applies to Aboriginal people. What does sentencing look for us? What do we think values should underpin that? What does health service provision look like? What does investment look like? And those sort of longer economic goals. And now I'm rambling rather than focusing on these questions.
Well, I better shut up because I was going to say something else, but I won't.
No, go ahead. Come on.
I was just going to say, if we built less prisons and we built less hospitals, we would have to find a way to make sure people didn't need prisons and more hospitals. That's where we should be, trying to find a way to make sure we didn't need so many prisons. We didn't need so many hospitals. That's where our focus should be. All of that prevention stuff. Let's look after people rather than institutions.
I 100% agree with you, Michael, but then where would those politicians get those little videos and photos with them in their high-vis vests and little shovels? You know, they'd have to come up with something else, maybe planting a tree or two. So the next question, Kin, is really for you, which is from Vin Wong, who's a law student, and wants to know, can you explain how exactly consideration of Section 3A should be applied by lawyers and magistrates in an ideal situation?
All right, that's a lot in, what have we got, 2 minutes, Narita, I think? So the first thing is, if I don't address anything, I would encourage that law student to get in touch with VALS, and I'm more than happy to, they can talk to some of our lawyers or even myself, and we can take them through 3A and how it works. Look, 3A is very much an expanding and growing area of jurisprudence. Sometimes it's applied well, sometimes not so well. I think the overriding consideration of 3A and how it should be used, and one of the best descriptions I've heard, is that it's a lens which we look at the entire bail application. So it's not just limited to conditions, it's not just limited to risk, it's the entire bail application. And if we were to look at the purpose of 3A, which is really to reduce the incarceration rate of Aboriginal and Torres Strait Islander people, that is the question that must be pushed home to the bail decision maker by the lawyer in every bail application. You are about, if the question is, you are about to remand another Aboriginal Torres Strait Islander person, and what that means you're adding to the overrepresentation of Aboriginal and Torres Strait Islander people in custody, but also it's not just a deficit. I think 3A should never be classed just as a deficit in court. It's also about highlighting the real kinship and family commitments that Aboriginal and Torres Strait Islander people have in the community, and how they are actually a strength and can actually go a long way to reducing risk. Also, how they can help successful rehabilitation and successful interaction with therapeutic programs, all of which need to happen in the community, not in custody. And by using 3A as the vehicle really to get these conversations into court about what is different about an Aboriginal Torres Strait Islander applicant for bail, what is different about this accused person, which goes to their ability to comply with bail, why they should be considered bail. It's that point of difference that needs to be ventilated in courts, because lawyers generally, VALS lawyers, I would like to think understand understand the community they represent, but mainstream lawyers, I think there's still a bit of work to do, and I think particularly for bail decision makers, there's a bit of work to be done. So, look, I probably haven't answered Vin's question, and it's because I think 3A, it's conceptually very difficult to sum up in about 2 minutes. But if I say nothing else, that what it is, really the drive should be that we push to see Aboriginality as, when it in the consideration of bail, that it's a point of, that it's not a deficit, that it actually is a point of consideration as to why bail should be granted, and it's the point of strength. The links and the ties that Aboriginal people have within the community is a strength in favour of contemplation of bail. But otherwise, Vin, please get in touch and we can take you through how 3A and the history of jurisprudence is going in the courts.
Thanks, Kin. And if I recall correctly, just a little while ago, perhaps a month or two, we did the VLA conference where we did a presentation specifically on Section 3A and how it should apply.
Yep.
So we can also link Vin in with that resource, as well as our human resource in Kin. So thank you to all of our panels today for a really important discussion. Over 30 years ago, the Royal Commission to Aboriginal in Custody recommended increasing access to bail for Aboriginal people and ensuring that imprisonment is a sanction of last resort. The current bail laws in Victoria have had exactly the opposite effect. They've made it much harder to access bail, and as a result, the prisons are full of people who have committed minor offences and who do not present any kind of safety risk. Thank you to everyone who's joined us via Zoom today. We really appreciate all of you taking the time to come and listen. If you want to support the work that VALS does, you can make a donation at vals.org.au/donate. And your donations give us the freedom to do the work we might not be able to do otherwise. That includes relief work, particularly in relation to natural disasters that we've had recently, but also providing emergency support so our clients can connect to kin, community and country. A reminder that if today's discussion raised any issues or concerns for you, we encourage Aboriginal Islander people to call Yarning Safe and Strong, which is a helpline run by the Victorian Aboriginal Health Service on 1800 959 563, and anyone can call Lifeline on 13 11 14. Those contact details will be shared in the chat section. To conclude the webinar today, we are pleased to be able to share a short animation, which is based on a case study from one of our clients at Bulitnalu, which is our legal service to Aboriginal children and young people. Thanks again, and I hope to see you at our next event.
Dylan is a 15-year-old young Aboriginal person. Dylan first came into contact with lawyers from Bulitnalu when they were at the police station seeking legal advice. Dylan had never been in trouble with the police, but they were arrested and charged in relation to a series of very serious charges, including aggravated carjacking and armed robbery. Dylan has a diagnosis of autism, ADHD, and an intellectual disability. Due to the nature of the charges and the lack of support available, Dylan spent a week in Parkville Youth Detention Centre. This week was a struggle mentally and emotionally. This was Dylan's first time being away from their family. Dylan was granted bail by a magistrate, and in addition to the involvement of youth justice workers, a number of culturally specific supports were put in place, including the Aboriginal Youth Support Officer at Bulitnalu. This intensive care team worked to re-engage Dylan in their culture. This included Dylan returning to country, creating art and paintings, participating in camps with other young Aboriginal and Torres Strait Islander people, and planning for the future. Dylan was also supported to set goals, return to school, and engage in other pro-social activities that were not in place at the time the offences occurred. Some months later, Dylan's court matters were ready to be finalised. The supports afforded to Dylan after being bailed provided Dylan with an opportunity to re-engage with community, culture, and family, which Dylan would otherwise not have had if Dylan had not been granted bail. It was these protective factors which ultimately led to changing the trajectory of their life. And as a result, there were no new offences after being granted bail. This was a notable achievement, and Dylan's achievements were celebrated, not just by his family and Balit Nulu, but by the court as well. Dylan was granted the opportunity to complete the diversion program. As a whole community, we worked together to give this child another chance to change their life without being held back by a criminal record at 15 years of age.